Welcome to The Point of View. This is your favorite current affairs show here on Channel 1 Television. On The Point of View, we pick the right topics, get the right guests, ask them relevant questions on issues that matter to you. There's a big question that has been posed to the OSP. Quo warranto? Who gave you the authority to do what you've been doing? Don't forget, the Office of Special Prosecutor was set up by an Act of Parliament in 2017, assented to in 2018, and the office has been in existence for 7 to 8 years. This past few days, a High Court has asked the question of the OSP, who gave you the power? And it appears, to all intents and purposes, that the OSP could not produce who gave it that mandate. And therefore, the court has ordered that the AG take over prosecution of cases the OSP has been handling until the OSP gets the necessary authorization. Tonight, we speak to the Deputy AG, who's been very active in court, to find out what this judgment means for justice delivery in the country and the existence of the OSP. Stay with us.
Number 1 from here, 2 and 3 from here, 5 and 6 from here, for now. Yay! Now, I have the number 7, 8, and the number 9.
You need number 10.
Please, I can't eat anymore.
I mean, number 10, liver salt.
The effective liver salt for the relief of stomach upset, heartburn, hyperacidity, and indigestion.
Would you like to try number 11?
What? JJ?
Number 10 liver salt. Refreshing relief fast. Manufactured and distributed by Ernest Chemists Limited. This advert is FDA approved.
Every dream starts with a prayer. And every prayer ends with a promise. At Blue Financial Services, it is our passion to make you smile, to show you that your smallest deposits can lead to major financial wealth. From the early days, taking that first big step to the days of joyous maturity, we will be with you. Visit our branch today for a better future tomorrow and trust in Blue Financial Services.
Welcome back. So tonight, my guest is the Deputy Attorney General Justice Sai, who has been interestingly named. Justice is the name your father gave you.
Yeah.
And justice is what you are trying to get in your work. But you're not a judge.
No, I'm not a judge.
So if you become a judge, you'll be called Justice Sai.
Yeah, and I will insist that...
You'll be called both.
Yeah.
Is this something you look forward to becoming one day?
Not at this time.
You prefer the bar to the bench?
Yeah. I enjoy the bar.
And what does a Deputy AG do?
You assist the Attorney General to do all the things that
he's supposed to do.
Yeah.
So is the power in the office or the person?
The person.
The person.
Yeah.
So he delegates the power to you?
Yes.
So if you go to court, you represent the person?
Yes, the person, yeah. The law doesn't... It's a human being that is... the law allows to be a lawyer. So you can't... Just like a director of a company, you can't use another company as a director of a company, or just like a priest, or
but you lawyers refer to
doctor.
Natural persons.
Yes, so
an artificial person.
Yeah, it has to be a natural person.
So the AG is a natural person.
Yeah.
How busy have you been? What are the key things you are dealing with?
So we attend court proceedings, but that's just about 30 minutes of the work, 30% of the work we do. Another 30 will be meetings. Then these meetings, we are talking of meeting prosecutors, meeting attorneys, meeting other ministers, state officials. That will be about another 20%. But 50% of our work is reading and writing and thinking.
Wow. It's a lot of work.
A lot of work.
So even today, I think you were on 3. How many cases do you?
Yeah, I did 3 cases today.
Which ones?
I did Skytrain.
Okay.
Then I did Edubuahen.
Okay.
And then I did the last one was Wuntumi.
Wow.
This has been my life for the past couple of months.
Prior to taking this post, were you more of a defense lawyer or a prosecutor? I'm asking this because you've been trained also in American tradition, that in Ghana we can do both, but in the US, you're either a prosecutor or a defense counsel.
Yeah, so the only people who prosecute are the state employees. This is my first time of working for the state, so I'm a prosecutor. But in civil cases, most of the times I'm a defense counsel, in the sense that people sue the government and other agencies, and we have to represent the government and those agencies. So.
I heard you say on a different program that this Archibald Hyde, is that the name?
Yeah, the gentleman who...
Versus the OSP. For which judgment was to the effect that the OSP should produce his warrant and that he had not been given that mandate. Yeah. That you heard of it when it was announced in the media.
Yeah.
How is that?
Yeah, because this is a private person who is being prosecuted by the Office of Special Prosecutor. Then he decides that he doesn't believe that the Special Prosecutor has the authority to carry out the prosecution. And his argument is based mainly on the Special Prosecutors, Act, which says that the Special Prosecutor, the Office of the Special Prosecutor may prosecute on the authorization of the Attorney General. So he basically went to court to cause the writ of quo warranto to issue. And this is how it works. If anyone is purporting to carry out a public duty and he doesn't have the authority, then he cannot, because the general principle of law, especially in the Anglo-American jurisprudence, is that for public officials, you don't exercise power unless you have been given.
Okay.
So if you're exercising any public power, you need to show that there is a law which gave you that power. Okay. That is the reason why you can't go and sit as a judge anywhere, or you can't do things that are reserved for the president to do. If you purport to do any of those things, the question will be asked, who authorized you, or by which authority are you exercising this power? Okay. So Archibald basically was asking the court to summon the Office of the Special Prosecutor and ask them, by whose authority are you prosecuting me? So we were not party to this case because it was basically a case between OSP prosecuting a private person who then decided that you don't have the power to prosecute me. So then he went to court. And it appears from the record of the court that the OSP could not show that they have the authorization of the Attorney General in their prosecutions.
Okay. It appears to me that the OSP's defense was that the act that set it up implicitly gave it the authorization. I use the word implicitly because I think they quoted sections of Act 959 on their functions and their mandate. And I think they quote 4.2 that subject to the clause 4 of Article 88, the office shall, for the purpose of this act, be authorized by the AG to initiate and conduct the prosecution of corruption. So it seems as if the OSP's understanding is that this act implicitly authorizes them to do their work. And the court disagreed. Where do you sit on this?
I do not believe that the act authorizes the OSP. I don't believe that the act authorizes the OSP, because from even the long title of the act and the section, the body of the act, there's nothing there which says that the OSP is hereby authorized. There are statements in the law which says that the OSP should seek the authorization of the Attorney General. There is an established way of authorizing persons to prosecute. Yeah. There are two main ways for public officials. It is by what we call an executive instrument. So if you look at the police, GRA officials, Senate, IOCO, we give them executive instruments to prosecute a certain class of cases. And even this, sometimes we give you the fiat to prosecute in a particular court. So you don't cross even to a different court to go and prosecute, even if it's the same offense. So the EI will specify the scope of the authority giving you, when to exercise it, and all that. That is the first way of doing it. The second way of doing it is by issuing what we call a fiat to a private citizen to prosecute. So, for example, when I wasn't a prosecutor, an attorney general could have just seen that, okay, this gentleman can prosecute this case, therefore we appoint him to do so. The Americans, I'm sure you've heard of the Americans using they have a special prosecutor where they appoint someone to prosecute matters. And I think their style of doing it is this. Whenever there's an issue, they would appoint a special prosecutor only for that issue.
Okay.
After that, he's off. They don't have a permanent special counsel who will be forever there prosecuting. And I think there's some wisdom in their approach. So then the issue of corruption and being used to the system, and also all that, and also dedication. So when there's a conflict between the attorney general and the person who is alleged to have committed a crime, what American law does is to allow the attorney general to make that appointment for that specific purpose. And once the person is done, case closed, to another one. So it is not just in Ghana that we have this issue. It's in almost all the Anglo, Commonwealth, common law jurisdiction. They all have these issues. So I think that solving this issue will require us to look elsewhere to see how it is done. But we are behaving as if we are the first people facing this kind of challenge.
Some people think that the two authorizations you described, the EI, which applies to police and other people, and then the fiat, which applies to private persons, that there could be also by an act of parliament. And they read, I think when they were debating this in 2017, I think it was Aban, who was then the deputy health minister, who said that, and he read 88.4, he says, all offenses prosecuted in the name of the Republic of Ghana shall be at the suit of the Attorney General or any other person authorized by him in accordance with any law. So in his argument, he says any law means that you could use an act of parliament as a way of also giving that power. And then some even argue that to the extent that when that act was passed, and then there was an LI as well that was passed, I think they call it 247 something.
Yeah,
2374.
Okay.
The AG at the time amended the signature to that LI. So it suggests to them that this is an authorization, right? So yes, EI is one way, fiat is to a private person, but then the OSP could have been authorized by that law. That's the way they see it.
There is a fundamental flaw in that school of thought. It is, first of all, it is only the person who has something who can give. You can't give what you don't have. That's a fundamental principle of law and also of life. Then the second thing is that who is making an LI or an act of parliament? It is parliament. Parliament doesn't have the power to prosecute in order to be able to delegate that power. So it goes back, the power to prosecute is in the Attorney General and its executive power. That is why the law says use executive instrument, not legislative instrument. So anything that Parliament does purporting to transfer the power or authorize anyone will be Parliament giving the authorization, which is a deprivation, a fundamental principle against, in constitutionalism.
So you can't delegate a power you don't have.
You can't.
But what about the fact that this law, it was the then AG, Gloria Kufu, who was the main promoter of the law. And some people even say to the extent that they nominate the AG, the SP, right? So they initiate a law, and then they are the promoters, and then they nominate the SP. So in a way, they believe that there are certain categories of offenses that the SP, just like Yoko, right? So maybe they didn't use an EI, because of course prosecution is an executive power. But once the president has given the Attorney General the power, in the process of coming up with this law, it was not initiated as a private member's bill. It was not some, you understand? So the AG was actively involved in setting up the law and willfully gave its power. So why are you saying they don't have the authorization?
So it goes back to another fundamental principle of constitutional law, separation of powers. Okay. Now, when you introduce a law into Parliament, be it on behalf of the government or on behalf of a private person, it is Parliament's exercising its legislative power. So your function of introducing the law doesn't convert you into a legislator to decide. So you can take a law to Parliament, Parliament will change or disagree with the law because it is their power that they are exercising. They are exercising legislative power. And that is why at the end of everything that the Parliament does on a law, there's a requirement that the tail end that the President should give his assent to the law. It is a recognition of the fact that this is what Parliament thinks. If you are ready to enforce it, you sign and give your assent that I'm ready to enforce it. If you are not, there's a procedure that you go back to converse with Parliament, have a conversation with Parliament to change it. If it's not, you veto it. Unless Parliament comes back to use a two-third majority to do it. So even though the institution or the arms of government are collaborating, they cannot take over another power, another branch of government's power. So if anyone is suggesting that by merely presenting the law to Parliament, even all laws in Parliament are drafted from Attorney General's Department, or even drafting it or helping Parliament to do something. By that alone, you have authorized or you have exercised executive power. That is not it. Executive power doesn't make laws, neither would legislative power delegate executive power. That is one side. Others also argue that by the LI, by submitting the LI and stating some things in the LI means that the AG has, when Parliament makes a law, like the 59, this Special Prosecutors Law Act 959 that we are dealing with, and command the AG to do something, and AG complies, AG cannot be said to have exercised its discretion. What this means that you have compelled the Attorney General to do something, or you have what we call fettered the Attorney General's discretion. A discretion which is fettered is not discretion properly exercised. So we need to keep in mind that we are still a country of separation of powers. When you have legislative power, you can use it in accordance with the Constitution. If you have executive power, you can use it in accordance with the Constitution. But you have no power as executive to go and take over legislative power and exercise it, even if you exercise in accordance with the Constitution. The same way, if Parliament cannot go and take executive power and say that it has followed the procedures for making law, therefore it has exercised it properly. So in constitutional law, there are three types of things we call limitations. And that is the embodiment of what we call constitutionalism. It means that when you have power, we need to limit you. We limit you as to institution. We call it institutional limitation. It means that when this institution is doing something, it cannot go outside its remit to do another thing that belongs to another institution. Then we have procedural limitation. Even if you are doing the thing within your institutional power, you have to do it in accordance with procedure. If you don't do it in accordance with procedure, it doesn't matter that you have the power to do it. It will still be nullified. Then we have the substantive limitation, which means that what you are supposed to do, you do just that and not another thing. These are all basic concepts of constitutional law. So in this case, those who argue that the AG has delegated through the Act or the LI, what they are basically saying is that the AG has allowed, the Parliament has taken over the power and has exercised it, so let's accept it.
So for you, the main issue is that a law passed as an act of Parliament is legislation.
It's legislation, yeah.
Prosecution is executive power.
Precisely.
So the two must be separated.
Yeah.
The things the AG does within the legislation are administrative at best.
Yeah.
Not origination.
Origination, no.
I see. So you think that this High Court was correct?
Yeah.
There was a small issue around what the High Court has done means. I think the OSP was concerned about the matter being a constitutional issue because they feel that if you agree with Hyde, you are interpreting Article 88. So you are, and that is, according to them, within the remit of the Supreme Court. Of course, the court disagreed. But isn't there merit in argument, especially when there's a pending Supreme Court matter involving one Adamte?
No, Adamte. Yeah.
Adamte. So did the High Court not preempt the Supreme Court? Because there's a more substantive suit of which your institution has even filed a defense.
Yeah.
Shouldn't the High Court have deferred to the Supreme Court to say, look, let's hear what the Supreme Court says before I adjudicate on this matter, because once I make a statement on, or I ask you where is your power, I have sort of forced the Supreme Court's hand in a way. Of course, the Supreme Court is not prevented from overturning that, but in a way, it should have been a bit courteous to say, let's wait for the Supreme Court. It could have.
Yeah.
So why didn't you do
You are
that?
perfectly right on that point.
Yeah.
The court actually stayed proceedings. If you look at the record of proceedings of the court, the Hyde Court stayed proceedings. But this will happen. It stayed proceedings somewhere, I think, in February, because the application was brought in January. It stayed proceedings with the hope that the Supreme Court would decide. But this is what happened. It appears OSP now went back to the court, the criminal court, so while Hyde was stayed in the civil court, OSP went to the criminal court, and Hyde was trying to pray the criminal court to also stay. So all of them will wait for the Supreme Court. But OSP opposed that and wanted Hyde to continue the trial
On the criminal side.
And I
Okay.
think the court granted that it should continue. So Hyde then came back to this civil court to say
And
that,
said this has forced our hand.
yes, because if they can't stay, then why should you
Because
stay?
of course the criminal is probably more serious.
If you are being prosecuted, you see that it's more serious than so. So the High Court said, well, if that's the case, then if they are in a hurry to prosecute, then let's give the decision. That's the first side. The second side, you also ask if the High Court interpreted.
Yeah.
From the proceedings, I did not see any evidence of interpretation, because Hyde's argument was quite straightforward. It says, your law says, that's the act. Your act says that you should prosecute on the authorization of the Attorney General. That's what we have in 4.2, Section 4.2. And also even the long title, they all say the same thing.
Yeah. And that to establish the Office of the Special Prosecutor as a specialized agency to investigate specific cases of alleged or suspected corruption and corruption-related offenses involving public officers and politically exposed persons in the performance of their functions, as well as persons in the private sector involved in the commission of alleged or suspected corruption and corruption-related offenses, prosecute these offenses on the authority
of the
Attorney General and provide for the related matters.
So you see.
That long title.
Yeah.
But it implicitly,
then you go
but
to-
that's the implicit point I'm making, that the long title says that we are doing it on the authority of you people.
No, it's so now you go
Back
to
up
the
to
body.
4.2.
Where that's the body.
Subject to clause 4 of 88 of the Constitution, the office shall, for the purpose of this act, be authorized by the Attorney General to initiate and conduct the prosecution of corruption.
So you see, the law says you'll be authorized, but you still have to go for the authorization, because the makers of the law know that they cannot give the authorization. So what they are saying is that you will be authorized to do it.
On a case-by-case level?
No,
Or,
it
because
doesn't-
how would that, what form would the authorization take then?
So there are, like I said, there are two forms. The EI one, which is more substantive general. So if we give you an EI to prosecute this class of cases in this kind of court, what it means is that you don't have to come back to us anytime you see a new case. You just have to continue prosecuting like that. You don't have to come back to Attorney General anytime you see a new case. So what the OSP, having been appointed in accordance with this law, what the OSP should have done was to write to the AG and ask for the EI.
Let's stay there. Why didn't the AG's office, on the basis of this law, just give the authorization? Because once you've passed an act, and the act title is very clear, right? So is it that your predecessors in the office neglected to give the authorization? Because I don't, from what I see here, why does the OSP have to come and ask for it when the law has already said that this has been established to prosecute on your authorization?
There is a bigger issue than just coming to ask for it or giving it. It is because the OSP believes that it is independent of the Attorney General. By this legislation, the OSP believes that it doesn't require the Attorney General to give it that authorization. That is why they never applied for it.
Because there's different types of independence. When I read the Hansard, Inu Safuseni said there was structural independence, financial independence, and I think he mentioned the third one. I think he said prosecutorial independence. So financial independence means that they don't need money from you. So that is not illegal. Structural independence means they don't have to be in your office. So I think the main issue is about prosecutorial independence.
Yeah.
And the prosecutorial independence is what the law is saying, that corruption and corruption-related matters has been hived off to you. So go and deal with those matters. So if the fact that they say that they are independent, you cannot interpret that to be a total independence, because there are dimensions of that independence.
You see, you said has been hived off to you.
Yes.
And that is where the problem is. And this is the problem. You cannot use an ordinary legislation to hive off something that has been given by the Constitution.
Okay.
You have to use the constitutional amendment process to achieve that hiving off. So that is so, even though the desire is to hive off, you need to follow the process or the procedure for hiving off.
Or carve out, designate some of.
Yes, so if you don't use that process and you are using another process, then again it goes back to the issue of constitutionality.
So in your view, an EI must be, an executive instrument must be issued to allow the OSP to have the mandate or the authority to do its work.
So it's a bit more complex. Let me just try to break it down. There's no one in this country, I've not seen any lawyer in this country who believes that you can create an independent prosecutorial authority without amending the Constitution. In other words, every lawyer like every proper lawyer agrees in this country. I think among all lawyers, regardless of their age at the bar, they all agree that to be able to create an independent constitutional, prosecutor, I mean the independent prosecutorial authority, you need to amend Article 88 to carve out that, because currently as it stands, all prosecutorial power vests in the Attorney General alone. So if you want to be independent of him, what you need to do is to go and amend Article 88 to achieve that result. Now, without amending Article 88, you have a situation where the OSP Act is saying that you have to prosecute on the authority of the Attorney General. So then it means that, desirable as the independence will be, all of us want that. But you cannot achieve it by using an ordinary legislation to hive off the power.
No, but I understand what you're saying. But the point is, we are nitpicking on the word independence, right? Because I've already told you that there are three types of independence. So the prosecutorial issue, the prosecutorial independence is the main issue here.
Yeah, that's the only issue. That is the only issue.
IOCO is financially independent of the AG, right? So IOCO can be said to be an independent arm of government.
Investigative,
yes,
but they are not
with delegated prosecutorial power.
Yes.
So if we wanted OSP to be completely independent, we would have called it Office of the Independent Prosecutor. But we're calling it Office of the Special Prosecutor. So the point is that maybe you are also choosing how to interpret the independence. Because you could have easily said, let's issue an EI for you. Because if you can give an EI to police, and you can do an EI for IOCO and SNIT, why can't you give the OSP an EI to allow it to prosecute corruption and corruption-related matters?
We have not refused to give the OSP.
No, but you're saying you are saying that you think that all lawyers feel like for OSP to be independent, they need a constitutional amendment of 88.
Let me just say what I said.
That's what you're saying.
Yes. So if you want the OSP, to be independent of the Attorney General,
correct,
and would not require the Attorney General's authorization, then you need to amend Article 88.
Correct.
However, as in this act, where you said the OSP requires the authorization of the Attorney General, then that authorization must be given before the OSP can function as a prosecutor. The process for getting that authorization is for you to apply, and then you are given. That is how it is done. But the OSP is refusing to apply because it believes that it doesn't require it and that it is truly independent. It's easy to apply for. It's a letter. In fact, it took the OSP more energy to litigate Hyde and all the other cases than to just apply. But so ask yourself, why are they not applying?
Did IOCO apply for?
Yeah, they apply all the time.
Did IOCO,
in the case of IOCO...
So did they apply on a case-by-case basis?
No, not on a case-by. On IOCO's part, they actually apply, and then we take the names of the lawyers that will be exercising the power and give them the EI. So it's
For
not
a year of how long does the authorization lapse?
for as long as the person is with IOCO, you will have that authority to apply, to exercise.
I see. So for IOCO, you give them, you issue an EI for specific lawyers. I don't understand.
So IOCO's case, not all the lawyers there are able to prosecute or initiate prosecution. We have given those who have it, we give them the authority to do.
Okay.
In the police service, the general classification.
Yeah.
From a certain rank, you can. So that is why you need the EI2. So you need to apply and specify the nature of your institution and how the power should be given. Then we give it in accordance with that.
I see.
But you see, the issue is not even about applying or not. The question is, why? Let's ask ourselves, why is it difficult for the OSP to apply? Because it's just a letter. It is difficult because the OSP doesn't believe that it ought to apply. And so it believes that it has attained that Article 88 kind of independence. And that is where we are, we are saying, if you read our submission,
but if the OSP believes it is independent, why does it accept nomination by the... Because don't forget, there's the office and the person.
Yes, I'm talking of the office.
So the independence... So see, the authorization is for the person. The special prosecutor, not the office.
Yeah, for the prosecution, it's only human beings that can do the prosecution.
So my point is that you have... If the OSP believe that they are independent of you, then it will be an absurdity for them to even be birthed by your nomination.
Exactly the point. So you have yes. So because that is their position, so they don't even see why.
No, my point is that once they've accepted the nomination, it means that they do understand that they have a relationship with you, and that they were birthed by you. Well, so they have received the mandate to prosecute on the basis that you wrote a law and you nominate the person, because the power is to the person. And once you nominate the person, that authorization is deemed to have been given.
Yeah, I would like to agree. I actually agree with your view, but there's another view, which is that you nominating me, you are only performing administrative function.
Come on.
Yeah, I mean that is the only reason why they will say they will accept the nomination and not be willing to what? Apply to be given the fiat.
You've nominated me to be a special prosecutor. That is a position to do a function.
Yeah.
So it means that, like what you do for the IOCO lawyer, you are saying that the human being occupying the position by this nomination has been authorized to prosecute. That's my understanding. We'll take a break.
Yes, I mean,
I'm not a lawyer, but this is the way I see it.
Yeah, I like your understanding as well.
Okay. We'll come back. This is the point of view. As you can tell, there are plenty of papers because lawyers are here. We'll be right back. Stay with us.
My line of work, a confident smile is everything. Kale Charcoal Toothpaste keeps me on top of my game and ensures my smile is always radiant and bright.
With the tiring nature of my job, we spend several hours under the scorching sun. To keep our teeth white and our breath fresh all the time, we use none other than Kale Charcoal Toothpaste. Kale Charcoal Toothpaste. You're on a Kessie and in a kit one.
Samayo Kendini, a who be here, Semetra Sapapadia to Amame Manfo, Kale Charcoal's natural ingredients, and a bomb is buying, a man is swing, Nesansu Mama Hotoso, a will beg you.
Kale Charcoal Toothpaste.
Choose Kale Charcoal Toothpaste for anti-cavity, whiter teeth, and fresher breath all day. Available in 80 gram and 150 gram. Grab yours today.
Kale, happy smile. This advert is FDA approved. Every dream starts with a prayer, and every prayer ends with a promise. At Blue Financial Services, it is our passion to make you smile, to show you that your smallest deposits can lead to major financial wealth. From the early days, taking that first big step, to the days of joyous maturity, we will be with you Visit our branch today for a better future tomorrow and trust in Blue Financial Services.
So our guest tonight is the Deputy Attorney General Justice Srem Sai, who believes the High Court in the Hyde case did the right thing in asking the OSP to produce its authority. Now, there's a bigger matter where in the Supreme Court, Noah Ephraim Tete Adamte has essentially sued the state, and the Attorney General is defendant in this matter, that the OSP law and what set it up is unconstitutional. And that, based on the arguments we've already heard, that the law, Act 959, is in violation of the supreme law of the land, because Article 88.4 says all prosecutorial power is vested in the Attorney General. And to the extent that this law exists in the form in which it does, it sins against this higher law. And as lawyers tell us, a small law cannot defeat a higher law, so this law is bigger. Now, there are a couple of things you need to address.
Yeah.
Number one, some people say that this Noah Tete Adamte guy is somebody you are closely associated with.
Yeah, so Noah was my one of the lawyers in my firm. I trained him.
Okay.
Yeah, like other lawyers as well.
So isn't that curious then that he this of all people in the world to take this matter up, when his mentor is Deputy AG, he decides to go and sue the state that the OSP is unconstitutional. It's very curious.
That's the philosophy of my law firm. In that law firm, the fact that you are the senior or the leader doesn't give you the power to direct all the aspects of the case that you are on. We appreciate and value independence of thoughts and all that. So I wasn't surprised that he has sued the office that I'm in now. And this is not the only case that he has. I think he has 2 or 3 cases pending against the Attorney General. You know, and it's not only him. The lawyer who represents Shafiq, the Wesley girls, he was also in my firm, and they have sued us and all that. So
and that matter is, I think, going to be heard
tomorrow. Yeah, we have it tomorrow. So I once complained of having my associates, you know, bringing Oliver and Co. always bringing cases, you know, against me. And someone was saying that means that they are still in the good spirit, and I have deviated. I'm doing politics, so I've lost my principles.
That's fair. But if that would have been nice, if it wasn't for the fact that your statement of defense, number one, it took over 4 months to come.
Yeah.
Some people felt that that was a bit negligent, because for a matter as important as this, something that he filed, it took you 4 months to.
Yeah.
So it's almost as if you were reluctant to defend. That's number one. And number two, your defense itself essentially seems like a sham, because you agree with everything Noah is saying, except to say you are defending. But all the things Noah said they should do, you didn't even ask them to disagree with one thing Noah said. So how are you defending a matter in which you seem to agree with the person accusing you?
So one thing we know is that being an Attorney General, you should have the public view when you are doing your cases. So you are not a private practitioner who has been paid and specifically instructed to take a certain position. We are both the party and also the lawyer for the party. You understand? So it took us. Let me take from the delay. It took us a long time to file this because we were basically examining every aspect of the case, the policy implication. Our attorneys have gone back and forth with us, and because we know the gravity of the case. So the delay in filing is exactly what you are concerned about. That why do you readily, you know, support the case of a plaintiff? But I also want to say that as a lawyer, professional lawyer, it's unethical to go to court with an argument which you know is wrong or you know you don't believe in. So it would rather be a sham if I would just say, because I'm the defender, I should just say anything to defend, to oppose the plaintiff. So it is not, it is inaccurate to consider it as a sham if you think it's a sham only because the argument we have made seems to coincide with that of the plaintiff. It would have been a sham if you knew that the argument you are making is flawed and you still go ahead to make it anyway. That would have been a sham. Now, I mentioned one thing earlier. I don't know any lawyer, okay, who thinks that you can create an independent prosecutorial authority in Ghana without amending Article 88. That is what Noah's case is about. Noah's case is simply that Parliament seem to have created an independent prosecutorial authority who did not even go for authorization from the Attorney General because they believe that they have by themselves and of themselves the power to prosecute. And so he filed a case to say that that cannot be the case. And so the court should strike down the section which purports to give them that independent authority. And then that is Noah's case. Our response is not exactly what Noah is saying.
I know.
Yeah.
But your response basically just restates the argument that this law does seem to want to take away your power that is here. And to that extent, this law is violating this.
Precisely.
That's what you are saying.
Exactly.
But that's what he's also saying.
Yes.
I'm talking at the end. You use different arguments,
different
routes.
So for lawyers, you know, when those who are not lawyers, when people go to court, they look for who won and who lost. That is what those non-lawyers always look for, who won and who lost. But for lawyers, we actually are not interested in who won and who lost. It's the quality of the argument, the nature of the argument that we focus on. So even though you would think that we are converging at the same point at the end of the day, the quality of the argument, the nature of the argument would matter a lot. For example, if I agree that Parliament can use ordinary legislation to more or less amend the Constitution or take away the power of the Attorney General, I am setting a precedent which is bad in the sense that one day Parliament will just get up and pass legislation and take judicial authority and give to someone else. And on that day, we will forget about the joy we are experiencing with the OSP and say, no, this is bad. Okay. But as a lawyer, it is the principle that matters to me, not the outcome. That is the only way that's what we call rule of law. So I will not be able to go before a court and look the court in the straight face and say, Parliament wanted to amend Article 88. There is a constitutional provision for amendment, step-by-step procedure that they ought to go through. They ignored it and used a different approach to seek to achieve the same purpose. And then I agree, as an Attorney General of a republic, that Parliament can do whatever it likes so long as the outcome is nice.
But I agree with you that. Yeah. But two things. We are not, you know, the fact that we are happy we are not all lawyers. Because at the end of the day, people's lives are at stake as to what happens. So even though the quality of the argument issue is very brilliant, the point is that the law as it is should be separated from the conduct of the person occupying the office. Because you've also said that the person has chosen or elected, based on their understanding of the law, not to apply for authorization. That does not necessarily mean that that does not necessarily mean that the law is wrong. It could also mean that the person sits, because don't forget, there was a special prosecutor before this one. At the time, the office of the AG did not have any problem with anything he did. Yeah. Fine, we can say that he did not necessarily apply for authorization. But my point is that let's assume that the officer heading the institution has neglected to apply for authorization. That does not invalidate the law, which clearly identifies that it must get authorization.
That's exactly the distinction between the Hyde case in the High Court and the Adamte case in the Supreme Court. The Hyde case in the High Court is simply saying, which we were not part of this case. Perhaps if we were part of it, our argument wouldn't necessarily be this. But the Hyde case is simply saying that your own law says go for authorization. You refuse to go for the authorization, so you don't have any authorization to do this. The judge said, when I see your law, that's exactly what it requires you to do. You didn't do it, so you can't continue to prosecute. In Adamte case, Adamte is saying that you have created an independent prosecutorial authority and you did it without going through the proper process of amending Article 88, to the extent that you did not use the proper process, then it should be set aside. These are the principles. That's why I said that for lawyers. And I
Professor, do you believe that this law has set up an independent prosecutorial authority when the law clearly states that even the title of the law clearly mentions the authority of the AG? So how can anybody say that the law as it exists since against 88.3, had it not been for the fact that the person occupying the position failed to apply for the authorization?
So this is where the distinction between our argument and Adamte's argument come in. Yes, so...
But what's your argument?
No, our argument, we even went beyond. Noah's argument, Adamte's argument focused on Article 4.2, Section 4 of the law.
Yeah.
If you read our argument, you realize that we touch on more than one section. We touch on about 5 different sections, giving different authorities. For example, the authority to reach a plea bargain. No one never mentioned it. Authority to grant what we call nolle prosequi.
So you are basically working together on 2 aspects of the same outcome, right? Because here is your statement of case.
Yeah. And I think at the opening, I even said, I think we mentioned that we asked that Noah's one be dismissed in part.
Is it? I didn't see that.
Okay.
All I saw was well, maybe you need to show me that part, because what I'm seeing here.
Let me see what
I have the.
Yeah, this is the motion.
So introduction. This draft statement of case is for and on behalf of the defendant, the Honorable Attorney General. The statement prays your Lordship court to dismiss the
plaintiff's case in part.
In the writ in part.
Yes.
More particularly, the statement prays your Lordship to adjudge and declare as follows.
Yeah.
That Parliament has, by an ordinary legislation, varied the constitutional prosecutorial powers. That by so doing, Parliament has access of its powers. So
you see, our argument is substantially different from Adamte, even though the two may reach
the same conclusion.
Yes.
But my challenge is that, okay, in the interest of justice, we also know that the Office of the Special Prosecutor applied to be joined to this matter.
Yes.
In the wisdom of the Justice of the Supreme Court, they said, no, you are not a party to this case, no problem. That was in the middle, before you did your defense.
Yeah.
Right? Now, you and Adamte are essentially saying this is unconstitutional.
Yeah.
Do you not think that for those who believe that this is constitutional, or at least we should have another body, whether it is OSP being allowed to join or a civil society group, to say, look, we believe that this law agrees with 88.3, and the only possible problem is how it's being interpreted.
Yeah.
If we really want to get the right outcome, we should not go to court with a case where the plaintiff and the defendant are both saying that the law is unconstitutional. I mean, what is that?
Yes, so I understand your concern, but to join a case as a party, the criteria is not whether you have a different argument to make. Otherwise, all manner of people will be joining cases. The criteria for joining a case as a party is different from being an amicus curiae. So the criteria for joining a case as a party is simple. Can the case be decided? Am I a necessary party to the decision?
Is that what the SP wanted to do?
Yes, SP wanted to join.
So maybe they can vary it and say, want to join as a friend of the court.
Exactly.
That's what they should say.
That is what they should say. They should file their argument and say that we think the court will be deprived of alternative arguments. So we are presenting this argument on this. If they did that, I doubt if the court will reject them. But you see, there's a lot of misinformation in the public, where people are assuming that they just want to argue and the court said they shouldn't talk. No, they wanted to be a party, and to be a party, a specific allegation should have been made against you, and no allegation.
They said the law that established them is unconstitutional.
Yes, and the allegation is against Parliament for making a law which is violating the Constitution. There's no OSP didn't make the law.
But it has
OSP is just a child.
I mean, again, they have 130 cases that they are investigating. They have 7 convictions, and when I say convictions, it's not like imprisonment, but convictions of different stages of law. They've done this for 8 years. Clearly, the outcome of the case impinges on what they've done.
Yes.
So they may not necessarily have been the ones sued.
Yeah.
You see,
so that is why they will be allowed. I believe they applied to make the argument as someone who wants to assist the court. They will be allowed, but they apply rather to say they want to be parties. And there's a criteria for being a party. And if you don't satisfy that criteria, you will not be allowed to be a party.
I see. I mean, sometimes these are public interest issues, and the thing is that law is a vehicle for
change. Yeah, for social.
So when it's, and again, I cannot criticize the Supreme Court, but I feel like the public has gone through 8 years of politicians telling us that they want to prosecute corruption.
Mm-hmm.
When you listen to the arguments of a lot of the NDC in opposition at the time, they seem to have an issue with the OSP. When you read the Hansard,
I mean, the law or the person or the
law.
The office. Okay, the law. Uh-huh.
So it seems as though this government simply does not feel comfortable with the existence of the office, and therefore is not willing to allow the office to exist. That's the way I see it, or from outside, it's a view. And so you are giving me legal technicalities, which may be well and true, but the public perception is also very important.
Yeah, so the public, and I think I need, or the Attorney General's department, we need to do more public education. There is no one in NDC that I know of, I have ever heard of, who is against an independent prosecutorial authority. Don't forget that this idea of independent prosecutorial authority was actually muted at President Mills' time. Okay, so there's nobody in NDC who is against it. When our manifesto was emphatic that we are not against it, but at the same time, at the time while we were saying we're not against it, we were clear in our position that to do this, to achieve this result, you need to amend the Constitution. And that if you do not do it, at any point in time, we predicted the Hyde situation. We predicted the Adamte situation. So you cannot say because you want something, you have to get it anyhow. That is even in normal life, in ordinary life, we don't do so. If you want a PhD, you go to what? You go through the process to get it. You don't say that because PhD is good, everybody, why? So you find another way of getting your PhD. And when they want to revoke the PhD, you say, oh, but I'm doing what PhD holders do.
I'll take a break.
Allow me to
I'll take a break and wrap up with a few more points. We're talking to Justice Sai, who's the Deputy AG, on some of the interesting issues arising out of both the challenge of the authority of the SP and now the constitutionality of the office. Stay with us.
Hey, Dr. Ramsey. Hey, how's it going? It's good. So when the patients come in, I usually say, we only do regular cleanings if your mouth is healthy, which means you don't have a lot of hard plaque buildup underneath your gum or above your gum line. You don't see a lot of bleeding when you're brushing or flossing. There's no shaky teeth, no inflammation going on.
Right. And if they do have all those things that you mentioned, then they need to have a different type of cleaning, which is called a deep cleaning or periodontal therapy. Also could be called scaling and root planning. Sounds a little bit scary, but it's not. Basically, you have a lot of hardened plaque underneath the gum line where you can't see with your eyes. And that bacteria is causing an infection. And that's what's causing the gums to puff up and bleed. Some people notice bad breath odor that no matter how they brush, they floss, it won't go away.
Healthy smile.
Launching. BSc Development Economics at the Ghana Christian University College. Study a job-ready university program, BSc Development Economics at the Ghana Christian University College. Job is ready for graduates who possess degrees and certificates in BSc Development Economics, professional certificate in Theoeconomy, certificate in Theoeconomy with business. Enroll at the Department of Theology and Economics at the Ghana Christian University College, Amrahia, Adenta Dodua Road, Accra. Full bursary is available for BSc Development Economics graduates to study master's program at a state university in South Africa. Enroll now. Take advantage of this opportunity to join elite professionals in economics. Call 0557 351 090 or 0575 633 307 or 030 296 0542. WhatsApp us on 0557 351 090 or you can get in touch online on www.theoeconomy.edu.gh. Powered by the Center for Theology and Economics, CTEC. Hello CEOs, Ghana's foremost business platform marks 10 years of leadership impact. Join the 10th Ghana CEO Summit and Expo on Thursday, 28th May 2026 from 9 a.m. to 5 p.m. at the Kempinski Hotel Accra. The summit is themed Accelerating Ghana's Economic Transformation, Driving Bold Reforms Through Leadership, Technology and Industrialization. Tagline, From Vision to Action. His Excellency John Dramani Mahama, President of the Republic of Ghana, will attend as special guest of honor and officially launch the CEO Government Compact 2026. Highlights include presidential CEO dialogue, masterclasses, panels, brand expo, CEO profiles, networking, and the Ghana CEO Excellence Gala. Register now at GhanaCEOSummit.com. Call 054-639-1970 or email info@GhanaCEOSummit.com. Powered by CEO Network Ghana in partnership with Deloitte, PwC, EY, GIPC, SIGA, University of Ghana, Media General, and the Multimedia Group. The 10th Ghana CEO Summit and Expo, a decade of leadership impact. T&C supply.
So the point of view tonight is doing a lot of law, and my guest is the Deputy AG. So there are two big issues. This Noah Ephraim Adamte challenge of the constitutionality of the Office of Special Prosecutor. The AG has filed a statement of defense, and Deputy AG is telling us that nothing prevents any other person from filing an amicus curiae, that is, as a friend of the court, to present some angle that can help the case. We really hope either the SP decides to do this, or even civil society groups who believe that the office, as has been set up, can work depending on how it is operationalized. Do we have the timelines for when the matter will be heard? Do you know?
We were given 7 days the last time to file. We are still within the 7 days. We intend to file it. I'm sure by now my would have filed. If not, then tomorrow it will be filed. Any moment from now, the courts, and we would actually impress on the court to hear this matter, because clearly it has to be decided for us to even take steps. The order of the High Court says we should take over the cases.
Have you done that?
No, we have not done that.
You are waiting for this one?
I've had a conversation with my boss this afternoon on it, and I think our idea is that we ought to wait for the Supreme Court's decision. So we see the totality of what should be done. It will be a bit much of a rush to start doing something now when we know that the Supreme Court decision will have a direct impact on what we are doing. So our position as of this afternoon is that we would wait for the Supreme Court decision.
And to the extent that there may be other cases that Special Prosecutor or Office has against other people in other high courts, and to the extent that a high court judgment may be advisory but not binding on another high court, it seems it could even lead to absurdities, because if I am a defendant in a matter in another high court, does that mean that on the basis of this high court judgment, that matter must stop?
It will be contemptuous for the OSP to go into any criminal court and continue or try to continue.
Even if the court is higher than the high court?
Yes, so if the court, so the order is against the office. Okay. It's not just specific in that specific case. So you don't have the authority. So on what basis are you now going to other courts to still prosecute when a court of competent jurisdiction says you don't have the authority to do so?
But we know we could get into absurdities, because there are a lot of cases that the OSP has been investigating, over 130 of them, and some matters have already been decided in the past. So does that mean that, for example, in the Yariga case, the so-called nolle prosequi under the previous OSP, will all of that be vitiated by this judgment?
Well, if you didn't have the power to start in the first place, you cannot, then the power to end it would also not be there. So it will be as if you never even invited Ayariga in the first place, let alone giving him any nolle prosequi. And so we need to look. I think we all should just look forward to what the Supreme Court will decide in the Adamte matter. That will bring at least some more, as we call, authoritative, solution to the issues.
Yeah. By the way, for purpose of education, the OSP cases include Republic vs. Ajeni Mboateng, AJ, PPA scandal, Republic vs. Charles Bisu on illegal mining, Republic vs. GES scandal, Republic vs. Northern Development Authority, Republic versus Oforiatta in the SML case, Temaport rice scandal. This is, of course, the Hyde case. The NPA UPPF scandal, Mustafa Hamid case, and the Joabing MC nominee case, alleged bribery during the election of MCs. So you're saying that even though the High Court has asked you to take over these cases, you feel like the Supreme Court judgment will be more final?
Yeah, in terms of larger public interest and for a proper resolution of this, we believe that the Supreme Court decision will be.
But since both of you are arguing on the same side, the Supreme Court can only decide what is on this. Because basically both of you are essentially saying that the law is unconstitutional. So until somebody else goes there with a different.
No, the Supreme Court is
not. Can we disagree with both of you?
Yeah, the Supreme Court is not made up of what we call dummies where we just tell them what to do and they do.
No, but does it not decide on what is in front of it?
No, at all.
Okay, I'm just asking.
No, so it's never so. In fact, there have been cases where both parties have agreed and the Supreme Court went another way.
I see.
Yeah, so it is not as if when we go and say what we have to say.
So Supreme Court can say even though nobody defended.
Yes, and they can still go the other way. Yes. So that is why, I mean, I understand the need to have multiple perspectives to the case. That is why I think that the amicus curiae, approach would be a more acceptable one. But to say that just because the two parties have agreed, the Supreme Court will just accept what they have brought, it doesn't work that way at all. And the Supreme Court has in the past been deciding cases regardless of what the parties have said. In fact, sometimes party A goes left, party B goes right. Supreme Court said, no, you have to go north.
Interesting.
And you have to accept that.
It's in the bosom of the judge, as they say. Thank you for talking to us. It's a very difficult job, so we wish you well in your doing of same. We've been talking to Justice Remsai, who's the Deputy Attorney General, on the very controversial issue of quo warranto. Where does the authority of the SP come from? We'll be waiting for the Supreme Court to decide on the Adamte case. Till then, thanks for watching. We'll see you next time. Bye-bye.